HIV/AIDS is one of the greatest crises facing South Africa. We have very high rates of infection and death. The single greatest cause of transmission, or greatest means of transmission of the virus, is not through sex or through drugs and needles. It's from mother to child at birth. 24% of the women who give birth in the public health sector are HIV positive. All of their children are at high risk of infection. Fortunately, an inexpensive antiretroviral drug administered simply at the time of birth dramatically reduces the rate of transmission. But the government refused to provide it on a comprehensive or extensive basis. Some senior people in government have a deep and quite extraordinary skepticism about the proposition that HIV causes AIDS and that it can be treated by antiretroviral drugs, despite all the evidence and despite the registration of the medicines by the regulatory body. But the government dug in its heels and refused to provide. A non-governmental organization, the Treatment Action Campaign, and a group of pediatricians went to court. They challenged the refusal to provide an inexpensive, life-saving medicine. The case went to the Constitutional Court, which held that the government had failed to comply with its constitutional duty to take reasonable measures within its available resources to provide access to healthcare services. The refusal was not reasonable. That was the test in the Constitution. The court ordered the government to undertake a comprehensive rollout of the drug, and it was a judgment which literally saved lives, which literally saved the lives of many thousands of children, small children. The Treatment Action Campaign is an umbrella organization, represents churches, trade unions, other organizations, and people living with HIV and AIDS. It monitored the implementation of the order. It campaigned in the media, it took the struggle into the streets in the form of marches, and it took the struggle into Parliament in the form of deputations and submissions. Its campaign was so successful that the government felt compelled to undertake to provide antiretroviral drugs not only to pregnant women, but also to others who need them. The court case made a difference.
Recounted by South African advocate Jeff Budlander, the Treatment Action Campaign case was one of several fine examples of using law in the public interest, represented to the FLAC conference in October 2005.
The event was organised by FLAC, the Free Legal Advice Centres, and chaired by the Honourable Mrs Justice Catherine McGuinness. Practitioners and experts in the area of public interest law and legislation spoke to an audience of about 350 people, which included members of the community and voluntary sector, the legal community, public servants and politicians. President of the Irish Human Rights Commission, Dr Maurice Manning, introduced the event.
The time is right in this country for a major leap forward. Now, we're starting from a fairly low base, again, as pointed out by Mel, that there hasn't been a great tradition and that the structures don't really exist. There is a great deal to be done. Nonetheless, I think the first task, and it will flow from today's conference, will be a raising of awareness generally and a spreading out from this hall today of just what the full potential involved in a development of public interest law is.
In conjunction with the conference, FLAC commissioned a report by researcher Mel Cousins. Here he describes public interest law and suggests some guidelines for its future development.
I think it's clear from the overall assessment that public interest law and litigation is at an early stage of development in Ireland. In terms of, if you look at law reform, if you look at litigation, community legal education, in all of those areas, if you look to other jurisdictions, they tend to have done more than we have. There tend to be examples which we can draw on. And in a way, I mean, it means it's very exciting for the people who are here. We have a real opportunity to shape the way that we go forward. We have a lot of examples to draw on, a lot of good practices which we can replicate. I think it was clear from the research as well that public interest law does have the potential to make a difference. Certainly, I mean, I spoke to NGOs, we spoke to barristers, solicitors, independent law centres, and there was a consensus across all the range of organisations that public interest law, whether it be through law reform, whether it be through litigation, whether it be through greater legal education, it certainly, all of them felt that it did have the potential to make a difference to disadvantaged and vulnerable groups. And in fact, I was surprised personally at the degree of unanimity, at the extent to which people working in this area felt that it did have a potential. And overall, there was strong support for the development of public interest law, which I think, if you just look around the room here today, I think it's amazing that such a large group and such a diverse group of people have come together to talk about it. I think FLAC and Atlantic are being commended for having done this particular research, for having organised the conference. It's obviously struck a note with people here. I think we need to take a structured approach. I mean, if we're at an early stage in development, we have the opportunity now to take a structured approach, to bring together all the different organisations and to ask where we need to go. I think we need to have a balanced strategy, not one that just focuses on litigation. I mean, I don't think litigation is a panacea. We're not going to, with respect to Julian, we're certainly not going to change the world by bringing cases to the High Court or the Supreme Court. It does have an important role to play, but it needs to be balanced with law reform, with legal education as well. We need to have a medium-term strategy. It's not something that's going to happen overnight. I mean, if you look at the organisations who are involved in the area, many of the independent law centres have quite limited funding. They're concerned on an ongoing basis about whether they're going to be able to operate next year. Many of the solicitors who work in the area tend to be the smaller or medium-sized solicitors who are putting themselves at personal financial risk to do some of this work. So we need to have a medium-term strategy to build up the capacity in the area.
Public interest law and litigation has developed in different ways in different jurisdictions. 3 examples from North America were offered to the conference. First, US human rights lawyer Fiona Doherty outlines an ongoing public interest case.
I'm here to talk specifically about one case that we filed earlier this year on March 1st, 2005, against our Secretary of Defense, Donald Rumsfeld, in federal district court on behalf of 8 plaintiffs, 4 from Iraq and 4 from Afghanistan, each of whom suffered serious abuse in US custody. And we're co-counsel in the case with the American Civil Liberties Union, the ACLU as it's known, in the States. And the allegations by our clients are very specific. They include death threats and mock executions, severe and repeated beatings, sexual humiliation and assault, forcible sleep deprivation, food and drink deprivation, and restraint in contorted and excruciating positions. Each of our clients was released from US custody without being prosecuted for any wrongdoing and without receiving any redress for their injuries. We are asking the courts to find that Secretary Rumsfeld violated both US constitutional law and international law, the international law that prohibits torture and cruel, inhuman, and degrading treatment or punishment. The suit is a civil suit, it's not a criminal action, and as such it's concerned with establishing the limits of lawful government policies and also about creating a record of what happened. Our aims are really threefold. First, to achieve some basic redress for our own clients. Second, to ensure that senior leadership is held accountable for the policy decisions that open the door to abuse. And third, to make sure that the abusive treatment of detainees is stopped.